Hello, my name is Abhishek, and we are seeing landmark judgments. And if you are watching this particular course for UPSC specifically, their effects, the effect of the particular verdict or particular judgment is also important. What effect they have on our society, on our judiciary, on our country, or on our people. You have also to study about their effects, and there are few cases like Golaknath case, Keshav Nanda Bharti case, Minerva Mills case. There are various references about these cases, and it's important. So I'm making this particular series, landmark judgments and their effects, to supplement your preparation for UPSC with respect to polity, right? So I'm also making polity courses. You can also check that. So let's start with our first landmark case, the Romesh Thapar case, and the second one is Smt Champakam Region case. Both cases are different, and these cases, if you look into them, they are not landmark judgments. You don't find any reference about Romesh Thapar case or Smt Champakam Region case. Very little reference will be, you will see in M.laxmikanth, but their effect is very crucial. Their effect is very important, and the effect is First Amendment. Right. So in Romesh Thapar case, the issue is with Article 19(1)(a), and it is related to freedom of speech. And this particular case, Romesh Thapar case, happened in May 1950. And what happened in this particular case? The Romesh Thapar was a communist, and he criticized Nehru's policy in his journal Crossroad, right? And he criticizes Nehru's policies very badly, right? And the case name was Romesh Thapar versus the state of Madras. Right, so in this particular case, the freedom of speech, Article 19(1)(a), was in question. Then the second case was Smt Champakam Rajan, and in this particular case, the name of the case is Smt Champakam Rajan versus the state of Madras. So both cases have the name of Madras in them, and this particular case happened in 1951. And what is the basis of this particular case? There was a order, communal government order in 1927, right? And it says it provides the communal representation in jobs and education, right? Now, in 1951, we have almost 1 year of our constitution. The constitution is implemented in 1950, and after the constitution is implemented, these two cases happen. In 1950 itself, Romesh Thapar case happened, and in 1951 the Smt Champakam Region case happened. And the issue in this particular case is that Smt Champakam Region says, okay, now we have our constitution, and the constitution provides for equality among citizens, and therefore the communal government order of 1987 must be cancelled, because it creates a discrimination in job and education. And therefore, yes, as our constitution talks about equality, it is a fundamental right, Article 16(2). And the court, what court will do? Court said that communal government order of 1927 is null and void, and it's unconstitutional. And therefore, after these two particular cases, Nehru, like Pandit Nehru, realized that, okay, we framed our constitution and it has various good features, but we have to curve the freedom or the fundamental rights a little bit, because in the name of freedom of speech, you cannot provoke someone to for crime or for murder of someone else, right? You may be giving hate speech, or anything. You are saying anything which is not correct, and then you are claiming that, okay, constitution has given me freedom of speech under Article 91(a), and I can say anything I want. So it's important to restrict the freedom of speech, and accordingly the reservation system somehow started from, it was present before, but it is given a constitutional status from this particular case, Smt Champakam Rajan. So these two cases lead lead to the first constitutional amendment 1951. They form a platform, you can say, to amend our constitution and to curb down the freedom of speech and to define the equality and to add certain articles which talk about that okay, we have equality but we also have a reservation system, and the state can take special care of children and women and backward sections and weaker sections, economically weaker sections, or the other backward classes of the society. State can do that. Yes, we have equality in our constitution, but in spite of it we can take care of the weaker section of society. Then the first constitutional amendment also curb down the freedom of trade, which comes under article 91G, and it says that okay, the constitution provides you the freedom of trade, but it also confirms to the approval of a state. You cannot be a say thief. You cannot be a thief and you do all the wrong things and then claim that I have freedom of trade as guaranteed by constitution. So first constitutional amendment also curbed down freedom of trade, and now whichever trade you must select must be have the approval of the state, that okay, this particular trade is okay and you can do this. Then the most important feature of first constitutional amendment and the most talked feature, right? You in the most videos, if you see, you always get to know that first constitutional amendment was on land reforms. Yes, it is correct that it was on land reforms, and land reforms was the one major aspect of first constitutional amendment, but it also curbed down the freedom of speech. It also curbed down the freedom of trade. It also includes article 46, and it says that state have the right, and it's the duty of a state to take care of women and children and weaker section. So these three things are also in the first constitutional amendment, and therefore this particular first constitutional amendment is very important. So then we have land reforms, and the first amendment edited or included 191F, and article 31A was included, article 31B was included, and 9th schedule was created. So 9th schedule was an invention by our legislature, right? Because in this particular case, Smt Champakam Rajan and Romesh Thapar case, the court declares a particular type of segment or a particular article or a particular law unconstitutional and invalid, and therefore the legislature feels that certain sort of things must have to be put out of the reach of judiciary, and scrutiny must not be done on them because they are necessary, and land reform was one of them. If we have to provide equality in our society, if we have to promote these values, and if we have to propel the growth of our country, we have to bring down these land reform acts, and these somehow breach the fundamental or violate the fundamental rights. So we have to invent something which which protects these land reforms, and therefore our legislature invented 9th schedule, right? So this is the whole scenario of these two cases, Romesh Thapar and Smt Champakam case, and the first amendment, and now we are going to see what effects they have. So just for a quick revision, Article 368 deals with the constitutional amendments, right? Remember that we are going to use this particular article in the upcoming cases like Golaknath and Keshavananda Bharati case, and we are going to see this. And what are the other effects? It created, these two particular cases created a constitutional dustbin, results in the creation of a constitutional dustbin, 9th schedule, because the 9th schedule was started with the aim of reforming the existing land distribution system, but now it becomes a constitutional dustbin. Any law you feel that it may violate the fundamental rights, and the court will scrutiny it and declare it null and void, the government put it into the 9th schedule, right? Then it put reasonable restrictions on fundamental right. This particular amendment put restrictions on fundamental right, like you cannot provoke someone for any crime or for murder or anything, and you cannot just do any type of trade, right? So it puts reasonable restriction on fundamental, and that this is the starting point of putting restrictions, right? Then it sets the tradition of amending the constitution to overcome judicial verdicts. So you are going to see this particular, the tradition of amending the constitution, and the judiciary also comes with innovative techniques. You are also going to see this tussle of power between judiciary and legislature, or the tug of war between them in the upcoming cases also. And then the policies for weaker segment does not violate right to equality, and this is also an effect, or a setup that this particular two cases set the notion that policies for weaker segment like reservation is a such policy, or any welfare measure the state take does not violate the right to equality. So these are the effects, and that's all for this particular case. And my FB ID link will be given below. If you want the PDF file of this particular case, it will be available. You can contact me on Facebook and I will give you the PDF. You can add me there also. If you want to suggest anything, you can comment down. Do subscribe my channel, and I'm also making videos on Unacademy. If you want to check that, you can type my name Abhishek Das there and you will find my ID. Thanks.